Good morning, everyone, and a very warm welcome to our Winter HRLaw webinar. We are nearing the end of an unprecedented year of challenge and change. Many of us, I think, will be quite glad to see the back of it. But how we work and where we work and how we interact with colleagues and customers, our clients and suppliers, is likely changed forever. Adapting to lockdown life and managing employees and employee relations in this new, largely remote world has perhaps overshadowed the most fundamental change coming our way on the 1st of January, of course, which is the Brexit transition period coming to an end. And we have various bills and proposals still on the books, which we would have expected to be enacted by now, but perhaps for obvious reasons have not been. But these give us an idea of what the government's likely focus is going to be in the year ahead. So there's a huge amount of change already. There is more to come. And what we're aiming to do in the next hour is to give you a briefing, which will first of all cover Brexit and the changing immigration landscape for EU and non-EU nationals, what you should do now. And Sasha will be leading that part of the session. Jane is then going to talk about COVID-19 and the challenges and how businesses have been adapting. And then I'm going to look at the employment law changes and a few key cases which you need to plan for and think about, which will have impact in 2021. So as ever, in the time available, it's very much a speed brief. But we have and will be expanding on the topics that we're covering in our HR law briefings and in future webinars. We will email out the slides afterwards, and there will be a recording of the session available so you can rewatch or share with colleagues. If you or your colleagues don't subscribe to HR law but would like to, we put a link into the chat function box you'll find at the bottom of your screen, or you can email any of us and we'll set you up on that. There is an opportunity to raise questions. If you pop your questions into the Q&A box on your screen, and we will answer as many as we can and as we have time for at the end of the session. So with that, I'm going to hand over to Sasha.
Thanks, Jo. Thanks everyone for joining us this morning. Now, so I'm going to talk about immigration and specifically with regard to the new system that's coming in upon us very shortly, and with regard to Brexit as well. And just a quick word initially about the basics of our entry into the UK. And what I'll be focusing on today is on employers and employees rather than any other categories such as students or visitors, because I'm going to be looking at the current and future points-based system and how that affects employers particularly. So as you'll all be aware, the UK currently operates a points-based system that requires UK-based employers to apply for permission for non-EU nationals to work in the UK. And they currently, and many of you will be familiar with this, work here under tier 2 of that points-based system. And employers, first of all, need to have applied for and obtained a sponsorship license. And once they are licensed, they can assign or issue a certificate of sponsorship or work permit to enable a non-EU national to come to the UK to work. And that non-EU national then needs to make an entry visa application, usually from their country of origin or their country of residence, to come to the UK to take up their post. And first thing to say is really that many of the current rules, such as I've just described, are going to remain unchanged under the new points-based immigration system. And the Home Office have also said that their aim is to make immigration with the new system much more accessible generally in order to attract more talent to the UK. And the changes that are coming in shortly and at the beginning of next year do to some extent reflect this. So the new system is going to go live on the 1st of December 2020, so just in a few days. And it does represent a major overhaul of sponsored migration. And the most important change is, and there's been a lot written about this, the ending of free movement for EU nationals. The government have said that they want to create a level playing field, and so everybody be treated the same as in EU as well as non-EU nationals. And it will means that the points-based system will be the only option for all non-UK nationals wanting to work in the UK. And the result of that is that it's going to become considerably harder for EU nationals to move to the UK as from the 1st of January 2021. And just a quick word about practicalities and timing. on the 1st of December, just in a few days' time, the new system is going to go live for non-EU nationals. For EU nationals, it will go live from the 1st of January 2021. And everything's going to be done online. The Home Office are doing away with requests for hard copies. Nothing's going to have to be sent in by post. All applications are going to be dealt with via the online portal, the sponsorship management system. Licensed sponsors amongst you will be familiar with this. So the skilled worker route first, and just to remind you that you do need, in order to access the skilled worker route, which is the replacement for tier 2, you need to be a licensed sponsor, because the heart of the new system is a remain sponsorship, and you need to then apply for and obtain a certificate of sponsorship in exactly the same way as you do now under tier 2 via the sponsorship management system. And in order to become a licensed sponsor, the business first needs to demonstrate that it is a legitimate employer in the UK, and they'll need to confirm there's a genuine need for an overseas worker to undertake the work in question. The employer is going to have to confirm that there is a genuine vacancy in the UK that needs to be filled. And before going ahead with the application, the potential skilled worker, or the potential person for whom the certificate of sponsorship is going to apply, has to have a job offer from that licensed employer, certain skill and salary thresholds. And again, because this is a points-based system, in order to qualify to come to the UK as a skilled worker, an applicant needs to have a minimum of 70 points, and they'll be awarded 50 points if first that they have a job offer from a licensed sponsor. That job meets the minimum skill level. And remember that the employer, in exactly the same way as now, has to match the role to a job description set out in the so-called codes of practice that are issued by the Home Office. You can't just make a job description that suits you as an employer. You have to match that to a one set out in the code of practice. Thirdly, and this is really important because it represents a big change, particularly for EU nationals, all applicants are going to have to meet the English language requirement, which is not something that EU nationals have had to think about before. And finally, the post obviously has to have met a minimum salary threshold, much as it does now. And again, those minimum salary thresholds are set out by the Home Office in the codes of practice. And this will again be familiar to all of you, but the visa, the certificate of sponsorship and visa, doesn't allow the holder to work for whoever they choose. It's, therefore much more restrictive for EU nationals than the free movement rights that they currently enjoy. So just a very brief word about the procedure and the way that it works in practice. The applicants have to provide a certificate of sponsorship, which is no less than 3 months old, and they then apply for an entry visa, either, as I say, in the country of their residence or within the UK, if they want to apply for a visa to reflect the change in their circumstances. For example, if they're here as working for another employer, or here as a student, for example. And the Home Office have said that they're very keen to reduce the amount of time it takes to bring someone into the UK and to streamline the system. So we'll wait and see if that happens. Just a quick word about intra-company transferees. I mean, these are similarly going to be dealt with under the new system. And it will allow for people who are working for branch or head offices abroad to come to the UK. There'll be a different minimum salary threshold, a higher minimum salary threshold. And most importantly, intra-company transferees will not be subject to the English language requirement. So it's a useful one to use if you want to come into the UK regularly from abroad, but you don't necessarily, as an applicant, want to settle here. Intra-company transfers are useful for that reason. So just a very quick word now about Brexit and UK businesses who employ both EU and non-EU nationals. This will be familiar to most of you, but for EU nationals, any business that employs any EU nationals will need to make sure those who are here now make their applications under the EU settlement scheme for settled or pre-settled status. I've talked a lot about this before, and there's been a big press campaign about it, so it'll be familiar to most of you. This is an application that is made using a smartphone app, known as the EU Exit ID document check. It's a straightforward process, and it gives people settled or pre-settled status depending on how long they have been in the UK. And it's EU nationals who are resident here up to the 31st of December 2020 who are going to be eligible and able to make that application. And they've got until the 30th of June 2021 to apply. But those arriving to work, for example, after that, will need to apply under the skilled worker route. And really important point to make, you have to make this application. It's mandatory, and it's mandatory not only for EU nationals, but also for their family members. And it's mandatory even for those who already have permanent resident status issued under the previous regulations. So it's important as employers to ensure that your EU nationals know about this and have made the applications that they need to have made. And they can't lose their settled or pre-settled status unless they leave the UK for a long period of time. I mean, to lose settled status, you have to leave for 5 consecutive years. Only then will you lose your right to return. And for someone with pre-settled status, you'll lose it if you leave the UK for up to 2 years. So that gives you an idea of what EU nationals are obliged to do and what you as employers need to ensure that they do. Can I have the next slide, please? So just to get back to this new system, and I just thought I'd run through a few of the key takeaways. The first and most important one of the new system is that the new system scraps the resident labour market test, the requirement to advertise. It's a really important takeaway for employers because it's going to make the process of obtaining a visa from outside the UK much, much easier and quicker. Basically, you won't have to advertise as you do now, and it'll mean that you don't have to wait 28 days before applying for your certificate of sponsorship for a new hire. And our advice, nevertheless, is do keep any evidence of advertising as an employer, because you may well be asked for that as proof that you have filled a genuinely vacant position. Another really important change is that the cap on the numbers of certificates of sponsorship has been suspended. So there currently is a limit on the numbers of certificates of sponsorship that can be issued in a year. That's going to be suspended. So meaning that the pool of applicants is going to be much larger than it is now. And the other thing to say is, well, apart from the fact that it's going to be much quicker without the cap, the fact that they've suspended rather than removed it would imply that they could reintroduce it at any time, and they've said that they intend to reduce numbers of migrants coming into the UK to work. So it's possible that the cap could be reintroduced. There are minimum salaries that are applicable under the new skilled worker route. The minimum salary for experienced workers is going to drop from the current level of £30,000 to £26,500. And for intercompany transferees, the minimum salary is £41,500. You won't be successful in getting a certificate of sponsorship for a skilled worker unless you can meet these minimum salaries. But there is a new concept of so-called tradable points, meaning that applicants will be able to trade characteristics such as higher qualifications against a lower salary to get the required number of points. And that's a change. There's a new post-study work route for students that's going to open up from the summer of 2021, and it's going to allow those who are studying in the UK to remain here for 2 years following their graduation and work in an unsponsored, not having to be sponsored. Giving them a lot of freedom. Actually, they can just take up any position they need at a licensed employer and work for 2 years following their graduation. It's still possible to bring your family members as a sponsored skilled migrant under the skilled worker route. You can work on the base, and those people can work on the basis that they are family members of a skilled worker visa holder. I want to emphasise English language. I haven't put this on the list, but it's really important to remember that, because it's not a consideration that EU nationals have had to think about before, and it is going to be from now on. And another major shift from Tier 2 is that there's now no limit on the amount of time a skilled worker can spend in the UK. Under Tier 2, a worker was only able to spend a maximum of 6 years in the UK, but applicants can now be granted permission of a maximum of 5 years at a time, and they can get unlimited extensions. So they'll be eligible in the same way as they are now to apply for indefinite leave to remain or permanent residence, freedom from immigration control, after 5 years in the UK. But their employer has to confirm at that time that they will be employing them. They intend to employ them for the foreseeable future. And similarly, just on indefinite leave, applicants have previously been unable to extend their visa or apply for indefinite leave or to remain unless they met strict absence criteria showing that they'd be continually resident in the UK. And under the new system, a skilled worker visa holder will be able to spend as much time as they want abroad without jeopardising their ability to remain in the UK long term. So that's really very good news and makes it a lot more flexible. So I think the conclusion to draw, just from the things I've mentioned so far, is it's going to be a lot easier for non-EU nationals to work in the UK, but it's going to be much harder and much more expensive for EU nationals who don't have settled or pre-settled status. Cost is the biggest consideration for many employers. So, I mean, obviously, it's positive that the new rules have abandoned the resident labour market test and there's no cap. But you know, the cost is very substantial. I mean, the minimum cost of just one employee's 5-year visa is likely to amount to just over £6,000 in Home Office fees, and it's likely that that cost could exceed £7,500 when you take into account the immigration skills charge and the immigration health surcharge, and that's before you've considered the extra management time and efforts put into the hiring process and the additional costs if the employee is going to be covered by accompanied by family members, because those costs are going to apply to them as well. So it's a huge financial burden on employers, and it's worth employers thinking about trying to avoid those costs by, for example, employing people who are already in the UK, thinking about unsponsored visa working routes such as the global talent route, or employing people who are here under youth mobility visas or UK ancestry. None of these will impose such excessive cost as those coming or staying under the skilled worker route. And next slide, please. So I just thought I'd quickly focus on a few practical tips and what you need to do as employers to get to grips with the new system. I mean, I've mentioned already, and I just say it again, even though it's not on the slide. Do think about your sponsorship licenses. I mean, if you haven't applied for a sponsorship license, then it's worth doing so now. It's worth reviewing your license if you already have one. The Home Office has written to sponsors to confirm that renewals can be submitted earlier than the normal month ahead of expiry. And it's really important to act as soon as you can on this, because obviously licenses are going to be so much more in demand, because people are going to have to apply, have them in order to apply to employ EU nationals in a way they didn't have to now. And the first thing I've put on my list here is the EU settlement scheme. I've already mentioned this, just can't emphasise it enough. Do inform EEA nationals and Swiss employees and their families about their eligibility under the EU settlement scheme for settled or pre-settled status. It's really important that they do that. Because it's going to mean that they can stay indefinitely if they choose to do so, but they need to be here before the 31st of December to have arrived and ideally taken up residence and be able to prove that they're here by the 31st of December in order to take advantage of the EU settlement scheme. They've got until the end of June next year, 2021, to apply. HR policies, really worth making sure that you review your HR processes to ensure compliance standards are met. I mean, the Home Office, as you'll be aware if you're licence holders already, sets very stringent compliance standards for employers of non-UK nationals, and they don't hesitate to revoke employers' sponsorship licenses if they consider that sponsors aren't abiding by the rules. I mean, they'll revoke a license even for minor infringements of the rules. And were an employer to have their license revoked, this would mean that they would need to, any non-UK nationals who are sponsored there would need to stop work, and the sponsor wouldn't be able to sponsor any more workers, and it could be disastrous, therefore, for UK for employers who rely on employing non-UK workers. And remember, there are a significant number of duties you need to comply with. You need to be sure that you can prove that there's a genuine vacancy. If you apply for a certificate of sponsorship, you need to notify the Home Office if an employee's duties change or their salary changes. You need to notify if the company, the sponsored company, the licensed sponsor rather, is the subject of a merger or makes an acquisition. You even need to notify the Home Office if the name or address of a sponsored migrant changes. Make sure you do that, and it's worth upskilling HR teams on sponsor license management and making sure they understand what the requirements of the new system in order to stay ahead of the curve. So just quickly to say, as I said earlier, think about other routes that you could use in order to avoid the skilled worker route, which is expensive and can be complicated, switching into another route, extending people's leave, and making sure that they and yourselves as employers keep abreast of absences. It's not a requirement that a non-UK national records all of their absences, but I always make sure that people do that, particularly if they think that they are going to be applying for British citizenship at any point. I mean, obviously, British citizenship I always mention because it's the only way to avoid or compliance with the immigration rules indefinitely going forward. You can make an application for British citizenship to naturalise after you've held settled status under the EU settlement scheme for 12 months, and you can apply to naturalise after you have held indefinite leave to remain for 12 months. But do watch dual citizenship issues. So I'm making sure that the country of your original nationality do allow you to hold your dual nationality. Just a quick word on timing. Our advice very strongly is act now, don't delay, certainly till the end of the year. Things are changing. You know, the new rules are coming in for non-EU nationals from next week. So it's really important that you as sponsors do understand what your obligations are. Okay, so happy to take questions at the end of the session. Thanks, Jo. You're on mute.
Thank you, Sasha. So we're going to move on to Jane now. If I can move the slides. I'm having some difficulty moving the slides on, unfortunately. Here we go. So Jane, over to you on COVID-19 and the challenges and how businesses are adapting.
Well, good morning, everyone. It's a huge pleasure to be talking to you today. And I'm one of the employment partners at Fox Williams, and I've been giving a lot of advice to employers during lockdown regarding all of the various employment law issues that this unprecedented situation has thrown up. And I know that this morning it's a rare opportunity to be sort of directly connected with some of you. So although we can't see you, you can see us. And I know that there are a number of friends and clients known to me in the audience and many new people. So welcome to everybody and those who watch the webinar later as a recording. And I am going to be talking to you today, as Jo said, about the various laws that have arisen during COVID. The pandemic has given rise to a lot of new employment law, and most notably the furlough scheme. but it's also necessitated the application of existing law to new circumstances. And those of you who've been receiving our HR Law newsletters will know that we've been covering these issues throughout lockdown. And many of the issues that I am going to talk to you about today have already been covered in the newsletter, and some of them will be covered in the newsletter. And as Joe mentioned at the beginning of the session, if you'd like to receive our newsletters in the future, then there is a function in the chat function where you can just sort of click through to become subscribers. And you're very welcome to do so. We've been aiming to give a lot of free information to employers, which we hope has been useful as our sort of doing our bit, as it were, during COVID. But the first topic I'm going to cover is working in the office. And this is a really funny one in a way, because normally the HR challenge is to get everybody to turn up for work. And the big debate at the moment is, are you actually allowed to go to your office if you want to? The current situation's on the screen. During lockdown 2, the principle is that indoor gatherings are generally prohibited, and there are restrictions on leaving home, but not where it's reasonably necessary for the purpose of work, or where it is not reasonably possible to work from home. And that legal position set out in the coronavirus regulations is supplemented by government guidance that says that everyone who can work effectively from home should do so. There's been a debate about what is effective working, and our view at Fox Williams is that's a mix of business and personal considerations. Are you going stir crazy at home? Do you have mental health issues that necessitate you appearing in the office to socialize and to feel better? Do you have the right equipment at home? And are you needed in the office for good reasons relating to the function that you perform? Of course, if you go to work, if your employer provides an office environment for you, it has to be COVID secure, and there's lots of guidance as to what that means. But next slide, because I think that from next week, from the 2nd of December, if you read the government's COVID-19 winter plan, and you have a close look at what it says about working in the office, that the position, I think, is subtly changing. For all 3 tiers, it will be permitted to go to work where that is reasonably necessary. I think that's the current position. But the government guidance looks as if it's going to be changing, which supplements the coronavirus regulations, because the government have said in the COVID-19 winter plan, the statement that's up on your screen, which says the government encourages employers to enable a greater degree of home working and will strengthen guidance to be very clear that anyone who can work from home should do so. And I have a feeling that that means that even if it's suboptimal to be at home, but if you can work from home, that's where you should be. And I think that is a subtle shift. And that looks as if it will be enforced during the tier system until the government's route map to get us out of this disaster involving vaccines and testing works, and we can return to some form of normality. There is still recognition in the COVID-19 winter plan that there are specific reasons where attendance in the workplace is necessary, such as mental health issues and the need to be on site physically. And we are, of course, awaiting yet another iteration of the government's guidance on office working. And as usual, there's a lag between Boris Johnson saying what things are going to look like and the government lawyers and civil servants catching up with the drafting of both the legislation and the guidance. So you have to keep an eye on the government's website in order to be completely up to date. But at the moment, as of this morning, that appears to be the position. Obviously, we're all waiting the big news today to find out which tier we're in. And there is some hope this morning that we won't be in tier 3 in London, which is what I've put up on the screen, but we'll actually be in tier 2, but we'll have to wait to see what happens. Next slide. In the government's COVID-19 winter plan, quite a lot is made of testing, and we've all been hearing about the Liverpool case study, where with the help of the army, lots of people have been tested using the new rapid flow testing system. And the reports coming from Liverpool are that that is being very helpful. And this throws up the possibility that employers may be able to use a testing system in order to help employees go back to work safely. And there are some private healthcare providers getting in touch with employers at the moment to suggest that they can make available tests to help employees return to work. And that will obviously build the confidence of employees that when they do go back to work, it will be safe for them to do so. At the moment, though, I feel this may be leaping ahead a bit, because if the government are going to advise everyone to stay at home if they possibly can be at home, this is more likely to be relevant to perhaps the new year, when it's possible to re-emerge and start going back into the office in a significant way. And at that point, I think the availability of rapid flow tests in large numbers, either through the NHS or through private providers, could be extremely helpful to employers. And that will throw up, of course, a number of ethical and other issues around, can you force people to have tests, the fact that that's a medical procedure, the use of personal data relating to testing, and so on and so forth. So obviously we'll be writing about that in due course in HR law, but at the moment I think that's probably something just to stick on your to watch list, along with something else which I saw in the paper yesterday, which is apparently the government are exploring whether or not we might technically be able to have vaccine passports. So that's going to throw up a lot of issues for employers around whether they can lawfully and legitimately and properly ask employees to flash a vaccine passport in order to get back into work. Another topic for a future HR law issue, and I haven't, to be honest, completely got my head around that one yet, and not yet ready to advise you on all the moral and ethical issues relating to that. Sticking with the current moment, and next slide, working from home. Well, we're all going to be at home for ages by the looks of it, while the government strategy for vaccine and testing gets underway. And this seems to me to be a moment where employers ought to be thinking harder about their health and safety responsibilities and responsibilities in general for employees at home. The key legal point is that all the health and safety legislation, including the Health and Safety at Work Act and all the regulations made under it, apply in the home workplace as well as in the office or the normal workplace. And it seems to me that it's now time for the employers to step up and ensure that everyone is working safely at home, because everyone's been at home for rather a long time now, and all sorts of problems are likely to be emerging relating to, well, eyesight, bad backs, ergonomic problems, muscle strain with hands, and of course all the mental health stuff that is talked about a lot in the media, but it's very real and serious risk for people, particularly if they're isolated on their own or going through very difficult personal circumstances. And there is, of course, a balance for employers as to how intrusive they should be in relation to employees' personal circumstances. But sticking with the legal position, the health and safety legislation requires risk assessments to be undertaken. That applies as much at home as in the office. The Health and Safety Executive, as always, are very helpful. They've provided a guide on self-assessments for employees to undertake at home using electronic questionnaires, and a sort of methodology for identifying workplace risks and implementing controlling measures. As I've just mentioned, the risks are not just physical. It's increasingly recognised that this way of working poses serious risks of psychiatric injury resulting from stress, isolation or exhaustion. And where there are these serious risks, these are reasons why people can go to work and work with colleagues in the office if it helps to alleviate these problems. Next slide. Also, the health and safety regulations require consultation with employees. And this is an opportunity for the HR and facilities teams to be reaching out to everyone, to help them with risk assessments, to chat about how things are going at home. You could maybe focus on the desk and the general setup, but it's also an opportunity for people in a fairly low-key way to check in with everyone and see how they are more generally. To have a one-on-one chat with how people are doing, and to allow people to raise any issues of concern about their way of working. And I think it's a very good idea for HR, line managers, colleagues to be keeping up in contact and engagement with employees on a one-on-one basis. And I know that's time consuming, but I think these circumstances are so extraordinary that it would be a very helpful thing for people to be keeping in touch, and in particular looking out for any serious health issues that are developing in the workforce, and whether the employer can do anything about helping the employee in that situation. One of the areas to think about, obviously, with an employee who may now be completely exhausted, possibly stressed, possibly, and in a serious way, suffering from some form of mental illness. These illnesses can be extremely serious. The employer can be talking about working hours, holidays, and what the employer can do to help. Maybe putting in place buddy and mentoring systems, video calls. And of course, there are the remote social events, but they don't obviously enable an employer to reach out to an individual personally in quite the way that I've been advocating. Next one. There's a big debate on about whether employers should provide equipment. Our view is you don't have to provide an entire new home office setup, but you do have to provide supplementary equipment to enable the employee's existing home setup to be supplemented by equipment needed to work remotely, such as screens, computers, mouse, etc., etc. And we think the employer should pay for that, but the equipment provided remains the property of the employer. The employee may argue that they're incurring increased costs of heating, Wi-Fi, etc. We think the employer isn't liable to pay for that, but they can choose to do so. An employee saying that, well, I'm incurring more heating costs may well be saving a lot of money on the commute, so it cuts both ways. And it's not the employer's fault that everyone has been asked to stay at home by the government. But the employer can choose to contribute to the increased cost at home. And there is a tax-free allowance of £300 a year, which helps everybody out. Next slide.
Yeah.
Oh dear. Right, thank you, Joe. As you can see, I'm not in charge of the slides.
Sorry, have I gone to the wrong one?
That's Joe's job. So, working from home abroad, one of the slightly amusing features of the whole situation has been people not being quite sure where everyone is, and some employers have sort of had a bit of difficulty tracking down their employees because, of course, not surprisingly, some people, particularly those with families abroad who come from overseas, have scooted off to somewhere a little bit warmer to work, since it doesn't seem to matter very much exactly where you are. Well, it doesn't matter very much if you've got a good Wi-Fi and it's all working in a practical way, but it does matter from an employment law and a tax law viewpoint. And if somebody has actually disappeared to work in the south of France, there are lots and lots of legal and tax issues to think about. Now, there's a bit of a checklist on the screen. There's a point about the employment contract and are you allowing a variation of the place of work? Obviously, most employers are going to want to take up the position this is a temporary variation to the contract necessitated by the pandemic. You do need to take up the position, I think, that your consent is required. And most employers are putting in place a policy on working overseas fairly rapidly to make the point, well, we do have some say in this. And this is a contractual issue. And if we're allowing it on the terms of a policy and it's temporary. This is not a permanent state of affairs, unless, of course, the employer chooses to agree that. So the next issue, of course, is tax and social security, because employees may become subject to tax and social security wherever they've landed up, and the employer might have to comply with local PAYE rules to deduct and account for tax. Employees who've gone to employee-friendly jurisdictions may be acquiring very good employment rights if you choose to make them redundant, and that could complicate the process and make it more expensive. And there may be some technical requirements to notify the government of the place where the employee is working that they're actually there and working for you. Next slide. Data protection and security, cybersecurity issues rear their head. Can the employees comply with the data protection laws where they are? And can personal data and confidential information be protected overseas? And there's a need for a data privacy risk assessment potentially. And of course, the UK's imminent departure from the EU without a trade deal complicates things as well. But I'm not even going to think about that one just yet, because I suspect we will have a trade deal. So let's not panic just yet. Another potential issue is insurance. Will business liability insurance cover an employee overseas? And there are, of course, the health and safety obligations I've just been talking about, not just the UK ones, but whatever applies where the employee is. And just the final sort of list of problems on the whole checklist is the possibility that if you've got a clump of employees, say in Paris, that you've set up a permanent establishment over there, and that might have consequences for the employer. So one way or another, this is something to pay attention to, and obviously you'll need specific advice on the specific circumstances. Once you've got to the got to the moment where the employee is returning home, either because they've decided to or you've asked them to, then obviously on return back, they have to comply with any quarantine rules, which generally means they do, because most places require quarantine, and it's an offence for both the employer and the employee to ignore that. Next one. Holiday. Our articles on holiday entitlement have been super popular on Lexology and generally, which shows that this is a really big issue. Furloughed employees accrue holiday and are entitled to furlough pay whilst on holiday. You can top it up though. Employers can require employees to take holiday. You have to give notice under the working time regulations, and the notice required is twice the amount of days that the employer wants the employee to take. Now, I think that's a bit aggressive in the current times, because the general rule is I think you want to be nice to everybody, but it does exist. And I think there is a line between requiring people to take holiday and consulting people about whether they've taken enough and isn't it time for them to take a break. And for those who just simply haven't been able to take their holiday due to reasons relating to the coronavirus pandemic, then it is a good idea to, sorry, I've just lost a screen. Right, back on. It is a good idea. Sorry, I'm going to start again, because the rule is that if it's not been reasonably practicable for a worker to take some or all of their leave to which they're entitled as a result of the effects of the coronavirus, they can carry it forward under an amendment to the working time regulations. But not being able to travel or not wanting to take a holiday during lockdown will not constitute an exception. So I think that's a fairly clear line there. And finally, I'm going to finish with a little bit of good news because I've been looking at the position for travel, starting with domestic travel and then on to international travel, where things look as if they might be about to improve. In relation to domestic travel within the United Kingdom, in all three tiers, if travel is going to be necessary for work, then it will be permitted, including travel between different tiers. Travel in tier 3 is going to be the most restricted, but even in tier 3, it's possible to travel on business and for work. You have to reduce the number of journeys, be sensible about that, but it is possible to travel within tier 3 or to move from tiers 1 and 2 to tier 3. And overnight stays are permitted in tier 3 where necessary for work. And accommodation providers in tier 3 are allowed to be open for people staying away for work. The government, as with all things and all aspects of our life, have issued some guidance on safer travel. And so employers should be making sure that their employees follow the guidance, which includes face masks on public transport, staggered travel, avoiding busy times, all of which means that people can come and go at more flexible times in order to comply with the safer travel guidance. And that should be encouraged by employees. And finally, international travel, which is where there is some more light at the end of the tunnel. International travel is permitted for work. One point to bear in mind is that we're so focused on our own rules and regulations that you have to think about what the rules are at the other end. So if the employee is going to another jurisdiction, that jurisdiction may require testing before departure or on arrival. And it is necessary for the employee to comply with the local laws and for you to look into that before they set off. On return, we're back to quarantine, and the current situation is the passenger has to complete the passenger locator form and self-isolate for 14 days if required, if you're not in one of the safe corridors. There are, however, some specific exemptions for specialist workers who don't have to quarantine, such as people working in power plants, essential infrastructure, some medical emergency stuff, and so on and so forth. But if you're not in one of those exemptions, then it's 14 days quarantine at the moment, and employers should not encourage or require an employee to attend the office. Otherwise, there could be a fine of up to £10,000, just one of the many ways in which we could all be fined at the moment. But light at the end of the tunnel, I've read somewhere in the Telegraph probably, which is usually fairly reliable in terms of knowing what's going on in government, that a government announcement is expected soon reducing quarantine from 14 days to 5 days, provided the passenger tests on the 5th day. And it could begin in December. It seems as if private companies will be assisting the airlines and the airports with testing. And if that is all true, and if it all happens, then it means that the opportunity to go away on holiday beckons, along with making it easier for employers to bring people into the UK, perhaps from America. There's been a lot of talk about opening up the New York-London corridor and from other key business destinations. So I'd like to end on a positive note. It's been a pleasure talking to you today.
Thank you very much, Jane. So I'm going to finish off with some key changes and key places to plan for in the year ahead. I'm going to look at what we know will happen and what we think might happen, and just wrap up with a few cases of interest. So, of course, we can't have a session today without talking about Brexit. And as we know, there's going to be no immediate changes to workplace rights from the 1st of January. There has been no official statement regarding any planned changes to employment law. What the government has said is that it's committed to ensuring that UK workers' rights do keep pace with those of EU workers. And we may possibly see some changes coming out of the trade deal negotiations, which Jane mentioned earlier. Now, it has been suggested that the government might look to change aspects of UK law with a basis in EU law, things like TUPE, working time regulations, collective consultation requirements. But we really are speculating here. So it really is a question of watch this space. And I think the general view is that this is probably not at the top of the government's to-do list right now. Of course, when we get to January, we're going to see a review of the extended furlough scheme, which will now run until, which will now run until the 31st of March 2021. And then the government will decide if employers should be required to contribute a proportion of employees' wages. Obviously, as employers, you'll need to assess how any changes to the scheme are going to impact your business. And of course, you've got to plan for when the scheme eventually comes to the end from April. It's not clear now what form the job support scheme will take. And that's the scheme which the government proposed. They would cover 1/3 of the difference in actual versus normal pay for employees on reduced hours. Because all the guidance has been removed from the government website, it's possible that that scheme won't now be rolled out at all. But again, we'll need to see what the position is. Now, hopefully, most of you will be well ahead with your planning for the introduction of the off-payroll rules for the public sector, because as you'll know, those were delayed relatively last minute and they were due to come into play last April. Now, the IR35 rules apply where an individual personally performs services for another person using a personal services company. And at present, in the private sector at least, it's the responsibility of the personal services company to determine whether there's deemed employment and if IR35 applies. Under the new regime, for services which are provided on or after the 6th of April next year, the onus is going to shift. So it will be the end user client who makes the status determination, and responsibility for accounting for tax and national insurance will shift to the fee payer. So if the rules apply to you and you haven't done so already, you need to carry out an assessment to determine whether the new rules do apply to your independent contractors, and you need to use the government CESS tool that you'll find on its website. You'll also need to review the contracts and pay arrangements for anybody affected under the rules. And it's a good idea to have early discussions with your contractors to ensure that you have continuity in terms of your resource, or to flush out where you may need to look for alternative resource if contractors don't accept the terms that are on offer. Now, I just want to mention the new employment tribunal rules. They're actually already in force. But I mention them because if any of you are experiencing the joys of litigation in the tribunal at the moment, you'll be aware of some really significant delays. And apparently there is a backlog of 45,000 cases. So we're only going to see the impact of these new rules in the current, in the next year. Now, the aim was to really streamline things like the ACAS pre-claim conciliation process, case management hearings, and to reduce bureaucracy. And we also know that the government is working on how better to support remote hearings. They are, in our experience, getting better at doing that. But we wait in anticipation and I think in frustration at the current chaos and confusion and the lack of communication that we're getting. We've written a little bit about the rules on HR law. So if you want some more detail, that will be the place to look. Now, in terms of what we think might happen in the year, there's a much longer list. So I'm going to start with non-disclosure agreements. In July 2019, the government announced plans for new legislation prohibiting NDAs being used to prevent individuals from disclosing information, for example, to the police, to regulators, or to legal professionals. And according to the press release, the updated legislation is going to make it clear, a requirement that it's made clear in contracts and settlement agreements that employees are not prevented from reporting to those particular bodies. And also it's going to require that individuals who sign NDAs get independent legal advice on the limitations of the confidentiality clause. So in the same way that it's a requirement to have legal advice for an effective waiver under a settlement agreement. We also understand that there will be new enforcement measures introduced. So for example, it's likely that an NDA in a settlement agreement that doesn't follow the new legislation will be legally void. Now, we don't know when this is going to come onto the statute books. We understand it will be when parliamentary timing allows, so who knows. But you've probably become aware that solicitors have been issued with warning notices by our regulator, the SRA, on the use of non-disclosure agreements, which make it clear that we may be disciplined if we use them improperly on behalf of our clients. So if you've been engaging with us or other lawyers around settlement agreements, you probably have seen changes introduced or been asked to make changes to settlement agreements, for example, to make it clear that employees won't be prevented from reporting to regulators or law enforcement agencies, and that they won't be prevented from whistleblowing. So if you haven't done already, now is a good time to update your existing template contracts and settlement agreements, because you will be asked to have these changes, and you will be eventually expected to have these changes in your documents. So on the subject of whistleblowing, the UK all-party parliamentary group on whistleblowing was set up to review our whistleblowing regime in the UK and the protection it affords or doesn't to whistleblowers. And they published their first report, which was included a proposed 10-point plan. Now, just a few highlights from that. It proposed extending the definition of whistleblowing to include harmful violations of integrity and ethics, even though those are not criminal or illegal. It advocated meaningful penalties and a review of compensation and how it is calculated. And it's also advocated the creation of an independent office of the whistleblower with power to set standards, enforce protections, and administer penalties. And it's made clear that its recommendation is that that applies not only to individuals, to organisations, but also to individuals within organisations. So again, another one where we're not clear when it will be adopted, but we expect some consultation on this in the new year. There is also a proposal to extend the time limit for pregnancy and maternity discrimination claims. This came out of a House of Commons petition committee who published a report making various recommendations to amend family-friendly leave and rights in the light of the COVID-19 pandemic. Most of those have been rejected except this one, and we're expecting a kind of response to that report to be published shortly. Now, perhaps the biggest piece of legislation we're expecting this year is the Employment Bill 2019, which was announced in the December 2019 Queen's Speech, and we expect it to be published in the coming year. The measures which are likely to be included in the bill are pretty wide-ranging, and several originate out of the government's Good Work Plan, which was published in 2018, and that followed the Taylor Review on modern working practices. So some of the things that we're likely to see, the introduction of a single labour market enforcement body, which is going to be put in place to ensure that vulnerable workers are better informed of their rights, and also to help support businesses to comply with their legal requirements. We're likely to see a new right to request a more predictable and stable contract after 26 weeks service. And that's really aimed at those employees engaged under contracts with variable and unpredicted hours, like people on 0 hours contracts, for example. We anticipate that flexible working is to be made the default position unless an employer has good reasons not to allow this if it's requested. And we're likely also to see the extension of redundancy protection, so that it will become automatically unfair to dismiss a woman by reason of redundancy if the dismissal occurs not just during pregnancy or maternity leave, but also in the 6-month period after the end of pregnancy or maternity leave. And there will be some exceptions to that, for example, if the business is closing down in the place where the woman's worked, or if there is really no suitable alternative employment that she can be offered if the work that she's employed to do is ceasing. Now, this comes out of the research carried out by the Equality and Human Rights Commission, which identified that during the last recession, women with childcare responsibilities were at a significantly greater disadvantage than men. And their research found that around 1 in 20 mothers were made redundant at some point during their pregnancy, maternity leave, or shortly after their return. We are also expecting some new rights for parents of children in neonatal care. So the right to take an additional week of leave for every week that their baby is in neonatal care, up to a maximum of 12 weeks. That leave will be added to the end of a period of maternity or paternity leave. And there will likely be some pay at the minimum current statutory rate for those with significant service, so 26-week service, and also who earn above the minimum pay threshold. And then finally, a right to have a week's unpaid leave for employed carers. And there was a consultation on this which closed in August 2020. The government response to that is not yet available. So again, not sure quite what form that will take, but we do expect it to come onto the statute books. Now, very briefly, just 3 cases I want to highlight because we don't have much time available to do more. The first one is a really, really important case, which was actually heard this year. But again, it's one of those things we're likely to see an impact on in the year ahead. So these are cases around post-termination confidentiality restrictions, which seek to prevent people from disclosing and using confidential information after they've left employment. And in P14 medical, the restriction which was contained in the relevant contract, which was being examined, was really something that we would probably regard as pretty standard post-termination restrictions that most lawyers will recommend and most employers have in their contracts and settlement agreements. But it was held to be too wide because it was purported to run indefinitely, and that it went beyond covering trade secrets to confidential information relating to the company's business, products, affairs and finances. And the judge held that it was only trade secrets which could be protected, not information which was, in their words, merely confidential. And the Investor Textiles case preceded that one and was on very similar lines. Now, in each case, the judge held that in the particular clauses it was looking at, it was not possible to take out the offending words in such a way that it left an enforceable restriction. And so that suggests to me that in the new year, to-do list for you, you need to look at your confidentiality provisions in your template documents and redraft them carefully so they can be severed if the courts reinforce this approach to avoid sort of being left with much less protection than you thought you had. The second case to mention is the Uber case. The Supreme Court heard the case on the worker status of Uber drivers in July 2020. Still haven't issued their decision. Uber are seeking to convince the Supreme Court to overturn the Court of Appeal's decision that Uber drivers are what we call Lim B workers, which entitles them to certain statutory rights, including the right to be paid national minimum wage and to take holiday. And obviously companies and gig workers alike are watching that with interest, given the potential legal and financial implications for both sides. And finally, a working time case, Flowers. This looks at the question of whether holiday pay should be calculated to include regular voluntary overtime. And obviously that will increase the cost of holiday to pay potentially. Yes, says the Court of Appeal, and the Supreme Court is going to decide that in June 2021. So we've got just perhaps a very short time for some questions. Sasha, one question that we have is around advertising for roles under the new system. Do you still need to advertise roles, even though the resident labour market test is no longer going to be in place?
Yeah, I mean, like I said, there's no resident labour market test. There is a genuineness requirement, though. So they haven't been specific about what they expect. I'm talking about the Home Office. What they expect sponsors to keep. I mean, they have set out a little bit on this in the sponsor guidance that was finally issued last week, but they won't be prescriptive over the location or the duration of any ads. And I think they just expect employers to produce any evidence if they're asked for it. So is it best to retain evidence of how you came to recruit someone? No harm in doing so. And I would say certainly do be prepared to be asked questions on occasion. Not a certainty, but it could happen.
Now, we've got quite a few other questions on immigration, but looking at the time, it's now 10 o'clock, so we've come to the end of the session. What we will do is to contact those of you who have raised the questions and give you some answers to those. So Sasha will be in touch about that, so your questions won't go unanswered. But I hope it's been a very useful session for everybody here. As we said throughout, please do subscribe to the HR Law updates that we issue, because they will contain more detail about some of the things that we're talking about, and also the sort of changing position over into the new year. So it remains to say, I hope everybody has a very happy, if slightly different Christmas to the one we usually expect. And thank you for joining us this morning. And hopefully you'll be able to feed back to us on how it's gone, and also whether there are other topics of interest, because there is a short survey that we'd like, if possible, for you to write a response to after the session, and that helps us to plan next year to deliver these sessions covering topics which are of most relevance and value to you. So thank you very much, and happy Christmas.
Bye.
Bye everyone.